It's so great to have a number of you join, especially Matt. I know I extended a special invite to you to join in. Welcome to the Admin Essentials series. I am Katie. I work at AUCD as a program specialist for our USED resource team. And we're really excited to have you join us for this event. This is a roundtable discussion, so we're gonna talk a little bit together. It'll be hopefully really interactive and a chance for people to share resources and different ideas. Our topic is on managing staff and volunteers who are under guardianship. The history, this discussion topic came from a question from our network about if other USEDs had kind of policies or best practices around hiring and managing staff who are under guardianship. And so we wanted to create this kind of iteration of our series to address the topic and see what people are doing around it and to share some resources. We've invited Kathy Costanzo and Anna Krieger from the Center for Public Representation to kind of inform our discussion on the topic, since they're both content experts on guardianship kind of at the national level, though they'll let you know, and everyone kind of knows that policies vary from state to state, so it's really hard to be an expert on guardianship for everyone. But our hope is that together we can kind of share resources and promising practices as we troubleshoot through how to support and manage staffs who are in guardianship situations. This event is being recorded, as I said. Following the event, a tip sheet will be made to kind of capture what we talked about and will be disseminated out to the network alongside the recording. We're asking that people can turn their cameras on. We have a really small group today. So if you're able, we'd love to see your faces. We're gonna have people share kind of their experiences and what they're hoping to get from the event as well. Thanks. I know it's early in Guam, isn't it? Appreciate you always being here, even though I know it's early. So thanks, Michelle. And our hope is when you're not speaking, you can keep your audio, your microphone on silent, sorry. Keep yourself muted to prevent background noise. Because we're a small group, our hope is you could just jump right in as we get to the roundtable part. And we really want this space to work for you. So whatever questions you have, bring them to the table. We're ready to have a lively discussion. There's gonna be a short evaluation survey with all of our events. Put it in the chat box once we're finished, and we hope you can give us suggestions for future topics, because it's requests from people in our network that make events like this happen. So with that, I'm wondering if we could each introduce ourselves and kind of say, you know, why are you here and what are you hoping to learn from our session?
I can start. Hey everyone, it's nice to see you. My name is Matt Giannino. I serve as the Associate Director at the Institute on Disability at the University of New Hampshire. And Katie, thanks for setting this up and for the invitation to join. I'm here more to learn than anything else. We've had a couple of instances where guardianship implications have come into play, and it was hard for us to really kind of find resources and best practice around this. So I'm hoping that today we can leave with some new information and new guidelines around how best to support our staff and volunteers. In our case, it was actually a member of our Consumer Advisory Council, and how best to support that member in the important work that they do with us. So glad to be here.
Hi everyone, my name is Michelle Aguigui. I'm the Associate Director here at the University of Guam Cedars. Like Matt, I'm here to learn. I just completed my first year with UOG Cedars, so yeah, just here to learn more about it. We don't have currently any volunteers or any employee who is under guardianship. So hopefully when we do, then I'll be prepared.
Thanks, Michelle. I see Jessica, you're on the line. Would you like to say a little bit about what you're hoping to learn?
Hi, can you guys hear me? This is Jessie Kenoy. I'm with ICI, and I work in the state of Missouri providing technical assistance and training to service providers, and the issue of guardianship comes up frequently. So I'm trying to learn as well, as other people said, and take information back to my team and to the providers that we work with. And I'm sorry, I'm trying to turn my camera on, but my Wi-Fi is down in my house, and so I'm joining you by phone.
That is okay. Yes. The last 6 months, I feel you with the tech issues, but I'm glad you're here, and I hope that we can have helpful resources for why you're joining.
Thank you.
Anna, do you want to introduce yourselves as well?
Sure. Yeah. Why don't you go?
Gotta unmute. Hi, everyone. It's so nice to see you. I can't believe we're like meeting virtually with folks from right here in New England and Guam. I mean, that technology is kind of amazing sometimes. So we're so excited for the conversation today. My name is Anna Krieger. I'm a senior attorney with the Center for Public Representation. Kathy's going to go into a little bit more about what Center for Public Representation is all about and kind of our different values and interests that brought us here today to talk to you. But mostly I'm just really passionate about empowering people with disabilities and making sure that people's legal rights are being protected and respected. So I think we're going to have a great conversation with that as sort of our umbrella or background today.
Hi there. I'm Kathy Costanzo. I'm the executive director of the Center for Public Representation. We call ourselves CPR these days. We are a public interest law firm, although we do a lot around policy work as well. We have our main offices are in Massachusetts, in the eastern part of the state, as well as in the western part of the state where we got our start in the Northampton area. But we have an office in DC also that does policy work, and we have another sort of lone attorney working out in New York State or New York City at the moment. CPR has been around for at least the last 40 plus years. I kind of lost count. We really see the focus of our work being to empower people with disabilities, to create opportunities for people to be full participants in their lives and in the communities in which they live. And I guess for those people who aren't yet in communities, to try to see that happens for them. So we do a lot of our work through litigation, but we also do, as I said, working on national policy issues around the settings rule and the Affordable Care Act, and you name it, we're kind of up to our eyeballs in it at the moment. We have an interest, for the last 10 years, CPR has been really focused on working in the context of the employment area. We brought the Lane case out in Oregon, which was a case to challenge the use of sheltered workshops as violating the Americans with Disabilities Act and creating a set of other opportunities for people to work in integrated competitive employment in the community. So I don't know if anybody, I guess the person from DCU isn't yet on, but we worked with Paul Wayman from DCU as one of our experts in that case. We work our experience there has been that lots of people who have guardians are working competitively in the community. So we thought we can kind of build on that and talk a little bit about that experience as well. We also, for the last 5 or 6 years, have been focused on supported decision-making, which is, as many of you may know, an alternative to guardianship for people who may need supports in making decisions, but not necessarily need to lose their full voice in legal identity by having a guardian imposed. So Anna and myself and a couple of other staff in the office have been spending a lot of time developing different models for supported decision-making and supporting individuals and their families and the people who work with them to support them and the people that they choose to have be part of their network to to function very effectively and to live full lives without guardians. So this question then about that came up around today's topic was one that we thought intersected with a lot of our interests and a lot of our experiences, and hopefully we have some things that we can contribute on both of those fronts. So we look forward to the conversation. Anna?
Should we just take it from here, Katie?
Sure. Yeah, go ahead. That's great.
Okay, great. Yeah. So I think we have, some different things we can go over. We'll kind of give you kind of just a quick overview of sort of our thoughts about what this all means, thinking about working and guardianship together. And then I think really quickly, let's turn this into a conversation about the particular scenarios that you all have encountered and or hypotheticals you're wondering about, and we can try to talk through and think about those. So I think the first point we really want to emphasize is just the idea that, there is a long and rich history of people with disabilities under guardianship working in paid employment in real community jobs, and we've obviously central to our work, promoting competitive integrated employment, connected to sheltered workshops. We've seen that, we've seen it time and time again that there's no correlation in our minds about whether someone should be under guardianship and whether or not they're capable of working. And I think that is really, when you really drill down on that, the reason there are statistics out there that show accurately, I think, that when you're under guardianship, you're less likely to work. And we think if you unpack that and think about it, it really comes down to a series of biases or assumptions about people with disabilities, particularly people under guardianship, where someone who might not know or understand a lot about what a guardianship is or means might think that automatically means they're incapable of working or incapable of being in community. And we obviously just believe that that's wrong and a false understanding. And so I think that those biases are part of what contributes to the lower rates of people working under guardianship. And the other dynamic we think contributes to it likely is guardians who, it's not just employers who might have some of those biases, but guardians as well, who might, have just a vision of the person who's under guardianship that is not a real reflection of that person's capabilities. And so as a result, the person gets fewer opportunities to explore the possibility of work and all of that. So I think we just really feel it's important when having this conversation to start from a place with and a shared value that people with disabilities are capable of working in real community jobs, and a guardianship should not be an impediment to that. There might be some glitches or problems or challenges that come up, but they're barriers that can be overcome. It shouldn't be a red flag or anything like that. It's more like a maze you might have to find your way through a little bit, but it's not a long maze, it's a short maze. That's kind of our overall message. Kathy, did you want to talk about the next sort of, or do people want to respond or challenge us on any of this? We have firm views and we're happy to be challenged on them.
I think you'll find that you're in good company today.
Yeah.
I think the other thing is, as we're going, if something occurs to you, you just want to ask about it as we're going, you should definitely, it's a small enough group that we have more than enough time to get through what we have prepared, and hopefully a lot more conversation that can then follow. So if there's not any questions at the moment, I'll continue then. There's nothing about guardianship that really precludes someone from working, okay? So that's the first thing. There's nothing legally about it. Practically, there may be some things to have to sort through. There's this idea of what a guardianship does. It either protects someone, and in certain ways it does do that, but it also restricts certain rights that people have, right? The right to decide things for themselves, the right to make some basic fundamental decisions. So depending on the nature of the guardianship, you can lose all sorts of rights, or you can have just certain of your rights restricted. Now, one of the things that's really interesting is that, and we'll be talking about this, but across the country, 63% of the state guardianship laws actually encourage guardians to encourage the development of the maximum self-reliance and independence of the person under guardianship. And so when you really think about that, and think about work as one manifestation of that, it really becomes quite clear that just because someone may be incapable of handling all of, if they inherited money, let's just take an example of somebody who may have had a family member die, may have inherited a certain amount of assets or have a trust set up for them or some money that they've gotten from their family. They may not be capable of managing investment decisions around that money. And so they may need guardianship around financial matters, but they may still be able to make certain basic decisions. And certainly, even if they needed help in certain areas or even a bunch of areas, that doesn't mean that they're incapable of holding down a job. And that, again, under those guardianship laws, that the guardian should not be serving as an impediment to that. Now, we recognize that sometimes guardians can be impediments to those things, and then we can talk about a little bit later what to do in those situations. But, I think to just understand that working and holding a job or participating as a volunteer in something that has a lot of status, that is gives someone a sense of connection and like a valued social role in our culture, is something that we should see as desirable and consistent with many of these guardianship statutes and arrangements. And by statutes, I mean laws, okay? A statutory law.
You're on mute. The phrase of 2020. I was on mute, sorry. We were just going to make sure we all kind of also had a common understanding of what a guardianship is, which I think probably we all do, but it's probably worth just taking a moment to step back and say that. And because I think we throw it around sometimes, but it can mean different things. Really, at its basic level, a guardianship is just when a court is finding that based on whatever the standards are in state law, a person lacks capacity to make certain decisions. And it can be all of those decisions, it can be some of those decisions, and we can get into the different types of guardianships in a minute. But basically, the court makes that decision about some or all of the types of possible decisions that are at issue, and decides, yes, this person does not have the capacity legally to make decisions on these issues. And then there's a court order that results in paperwork, basically, that says this person is under a guardianship. Here is the list of areas that this guardian is covering. So I think sometimes it's easy to forget that there's actually a court order, that it's not just an automatic process, all of those things. So I'm sure we all have that understanding, but we thought it was worth sort of stating that explicitly. Oh, Kathy, you're on mute.
I realized it as I was saying. The law on guardianship is going to really vary from state to state, and so really we can tell you what is we could talk about trends nationally, but we could not be able to speak to each guardianship arrangement in your state or your territory. So I think one of the things that CPR does is provide training and technical assistance to the Protection and Advocacy Network. So for all of the various states and territories in the country and beyond. And we, in doing that, recognize that each state has certain ways of doing things and certain statutes that are not identical to their neighboring states or even a state across the country. So guardianship statutes are one of those places where there's a great variation. There are some common themes, but we think it's really important for you to become familiar with what the law in your state requires, whether you're one of those states that are in that 63%, where independence and self-determination and so on is encouraged for someone under guardianship. And even if you're not, it still seems like it would be good practice for a guardian to be engaged in those behaviors and trying to support the individual in that way. I think it gets very complicated, and I'm sure, like, I don't know if in each of your jurisdictions, but let me just say, in Massachusetts, we unfortunately have a lot of what are called corporate guardians. They, you know, sometimes are guardian for, or even private attorneys who serve in that role of guardian, and sometimes will have 100 wards that they're responsible for. And so the idea that, you know, they were going to have, you know, very individualized relationships with each of the individuals they're responsible for, and actually be encouraging and fostering that kind of independence and supporting that and ensuring that the person's, you know, gaining additional skills and so on through life is probably not very real given those arrangements. So, you know, I think we have to recognize, and some of those corporate guardians in Massachusetts are fairly progressive and some of them are awful. And so it really just depends on who the individual you're going to be coming into contact with, who may be wanting a job with you or to be working with you on a project or so on, or volunteering even, who their guardian is, because that's in part going to, not just the statute, but actually in your state, but who that individual is going to be another consideration. One of the things that's come up is, so if you're, there's nothing, so again, depending on what the law in your state is and what the actual guardianship order says, it may be that the individual under guardianship retains the ability to enter into a contract, such as an employment contract, or to agree to be a volunteer, or to do the, and so for a lot of your projects, I would assume that there's some kind of, if it's a contract for employment, the person will have papers that they have to sign, and you know, employment papers and about their benefits and so on and so forth. So, you know, one thing to know is whether the person's guardianship extends to cover that. If so, whether the guardian's willing to delegate to the ward their ability to sign those things, or whether the guardian needs to be involved in reviewing them, or having the individual and the guardian sign them together, or, you know, both to sign off on them, or so on and so forth. I think even for individuals under guardianship, it's very important that somebody be explaining all this to the individual in a way that they can understand it. And so hopefully that happens through the guardian, but also if you're offering a person a position of some sort, that you're also taking the time to do that as well.
And I think connected to that, oh, sorry, go ahead.
Sorry, I was just going to interject. It seems timely to ask a question.
Mm-hmm.
This is really helpful information, Kathy. I feel like there's something that needs to precede the kinds of conversations that you're describing right now. So particularly where the potential relationship is not as formal as employment, say in an advisory capacity. What are best practices around initiating, identifying if there is in fact a guardianship situation just to begin with? And what are we legally bound to? From an HR perspective, there are specific guidelines around inquiries around health and disability and things of that nature. And I want to just understand, how do you best initiate the conversation related to guardianship before we get into the details of what the guardianship design, restrictions, language looks like?
Let me say, I'm not sure, but so we can talk about it. Let's just kind of talk through the nuance of this. Jessica, we're working with ICI on a grant right now. We're 75% of the individuals that are going to form an advisory group for the grant have to be people with intellectual disabilities. And, you know, that's a great thing. So, but, you know, I think we're going to be facing exactly the same question, you know, like, do we just invite the person? Do we have to invite the person but ask permission? How do you know if you have to ask permission of someone other than the individual who that needs to be. And I think we just need to try to have those conversations in ways that are really sensitive to the individual. But I think it's fair to say, you know, as you're getting to know someone, that we would like to think about, we would like to get to work with you more. And we would like to know if in doing that, we need to, whether you have a guardian and whether we need to include that person in the conversation. I think that might be one way of asking it without making the person feel badly. Or, you know, we could just say a lot of the people we work with from time to time have had guardians, and it's important if you have one that we know who that is so that we can figure out with you if we need to include them in the conversation. I don't think it would be to not continue the conversation with the individual, but really to think about who else might need to be included, either in that same conversation or in a separate one.
Mm-hmm. Yeah, I think my instinct is similar. My main message would be not to create a problem where there isn't one. You know, so I think there's not, you know, particularly for someone in a volunteer capacity, there's not going to be something in a guardianship that says this person is restricted from, you know, serving on a board or associating with certain people. That's not the kind of things that are going to be coming up in a guardianship order. It's more about like, it depends on the state, obviously, but an order is going to contain things like finances or healthcare decisions or those kind of things. So my sort of gut feeling is similar to Kathy's, which is that, you know, if you have someone who's approached you and is interested in being, you know, serving in an advisory council or of some kind or other, that it's about, you know, getting to know the person. And unless the guardian is raising some kind of issue, I don't really see that there'd be any guardianship creates any barrier, particularly to just serving on an advisory council. And I think, you know, framing everything in terms of like empowerment and, you know, making sure that the person understands that any inquiry you are making about a guardianship isn't that you want to bypass them and go to the guardian, you know, for, you know, to subvert that person's voice, I think is really, is important. And that's implicit in what Kathy was describing. So I think we're.
Yeah, I think though, in the grant that I was just saying that we're doing with ICI, we're going to be dealing with youth between the ages of 14 and 26 is the way that the federal grant has defined the population of people. So obviously for in different states, people reach the age of majority at a different age. So in Massachusetts, if you're 18, basically, unless a guardian's been appointed, you have the legal voice to make decisions for yourself. But it really varies according to each state at what age that happens. So at least in states, so I, you know, as I was just sitting listening to your answer, Anna, and I was thinking, yeah, but like think about this for some of the youth that we're going to try to get to be on our advisory council for this grant. Some of them are going to be between the ages of 14 and whatever is the age of majority in their state. Their parent / guardian somebody needs to probably be at least accepting of it, if not like excited about it, you know? And so, yeah, it's just, you know, those are just certain realities. I think there's a way to still involve the person and work with the person and talk to the guardian if that's what's needed. It may not be needed. It may be enough for the person to speak to their parent or their guardian and to, you know, get a green light to go right ahead. Mm-hmm. But to the extent that it isn't, then that's, you know, where we all have our work cut out for us.
Yeah, and I think the challenge is not like just really making sure you're applying the same standards to someone you're working with who has a disability and who doesn't. So if, for instance, you had an advisory council that was just youth, you know, not youth with disabilities, would you be asking them to get parental permission before joining? If yes, then I think you apply the same standard to a council that includes people with disabilities. So it's just about, I think sometimes that's a helpful framework to apply when you're thinking about these things, you know, making sure that, to make sure that you're sending both doing things the right way and sending the right message to to the people you're working with about, you know, how you value their voice and their independence.
You know, Matt, it might be that, yeah, you could just say, you know, in the event that you have a guardian, you know, it would be helpful for you to talk with them about this. And if we need to, you should let us know, you know, and that might be a way to sort of raise this subject without necessarily making the person have to tell you something that they may not be prepared or wanting to talk about, in the same way that you can, you know, you have to stay away from certain other subjects in HR context.
Yeah. Yeah, and I think it's tricky because I think just to be really, you know, candid, I think there are some people who would rightfully be offended, you know, if they, you know, you assumed that they had a guardian and they didn't. And so how you approach that is both a matter of like, is an important, you know, you're sending an important message in the way you ask it. So like I'm just thinking out loud here, another way you could consider approaching it would be to talk to the person and say, is there anyone, you know, we want to make sure this is an accessible process for you, that your participation, you know, meets all of your needs. Is there any accommodations you need? Like, are there any supporters that help you, that, you know, understand how you communicate well? You know, just giving some examples of the types of accommodations you've made for people in the past. And you could include in that list something connected to a guardian, so that issue is sort of raised. But I don't think it's like necessarily taboo to raise it in a direct way. But I think you, like Kathy was saying, you know, she was, I forget your exact language, but it was very good in terms of like raising it without assuming, you know, anything about the person, because I think that's really important.
Matt, I'm wondering where you are in, I know that the original request was a while back, so I'm wondering how this has played out in your situation and kind of what steps you've taken, just because I think it might be helpful for others in the network through your example, if you are able to share.
Unfortunately, I can't share a lot because it's sensitive in nature. I will say a couple of things. One is that for us, guardianship would never represent a barrier. And perhaps the exact opposite. 100% of our consumer advisory councils are either individuals who experience a disability or are a family member of an individual with a disability. So, so this is, yeah, so this would not be a barrier in any way. I think, you know, where we kind of have struggled is, one is, you know, identifying individuals that we're working with, particularly who are under volunteer status, whether or not they have a guardianship at the outset. And then secondly, understanding the details that pertain to their role as an advisory member, that would be helpful for us to know. The third thing I would say to your question, Katie, is where you know, usually this is a non-factor. Where it came into play for us was actually through a process of mediation and conflict resolution. And if and when it is necessary and appropriate to bring a guardian into that conversation, right? So we're not talking about executing a contract or anything else of legal status, but because there was an issue that arose that was sensitive in nature, it did require some conflict management and mediation. What was our responsibility as it pertains to dealing with that with a volunteer, with a guardian?
Was it the idea that the guardian could be helpful, or that the guardian was your concern that the guardian could be helpful in the mediation, or is the concern just that there's this conflict and the guardian needs to know about it for some reason?
Well, we didn't know, right? So we didn't know one way or another if the guardian needed to be involved at all, because we didn't know the details of that guardianship. Actually, initially we didn't, so we weren't asking the question, right? So, you know, your point earlier about, you know, creating kind of equity and how incoming candidates for these kinds of opportunities are treated, you know, the same across the board, and asking that question in a kind of on every instance, similar to how we would ask for questions related to accommodations and accessibility, makes a lot of sense to us. And I think we could address that issue right from the start. You know, I think the next question is, what are we, what should we expect in terms of understanding the details of that guardianship arrangement, right? So understanding what those details are as it pertains to their role with our organization. And then finally, if there's some ambiguity, if there's some gray area, which I feel like we were in when this situation arose, when is it necessary and appropriate to bring the guardian into the conversation? Because it's not necessarily a legal matter.
So I guess I would think if you kind of go back to Anna's construct of like what's a normative thing that would be done for anyone, if you think about even so, I was thinking about the situation of like your first job or your first involvement in something outside of your family, with your parents not there every day with you, not school, but just thinking about my first job. So if I messed up at my first job, if there was a problem at my first job, I did something wrong, or my behavior wasn't appropriate or whatever, at least in the first several instances, I think that there would be no reason to involve, there would probably never be a reason to involve my family other than if I stole a lot of money, or what I mean, there was going to be some kind of criminal prosecution of me. On the other hand, if I was at my job and someone sexually exploited me or did something that placed me in some kind of danger in the workplace, then I think that the responsibility of the employer to notify my family as my as my adult guardians, I think maybe there would be some responsibility to, if there'd been some kind of sexual abuse at work or whatever it was, then I think that, I think so I think it really depends on where on the spectrum the thing is, and I know that's probably not the kind of hard and fast line that you would like to get from me, but I don't know how to answer it any other way.
Yeah, it is a little squishy, I guess, right?
Yeah, but can you say more about the situation?
Yeah, what I can say is a couple of things. One is our mindset, once understanding of the issue, was to treat the situation and the individual as in any other adult volunteer member of our Consumer Advisory Council, and that's what we did. What happened was when the guardian, which in this case was also the parent, learned that there was some communication between our organization and the individual, let's just say it exploded. There was definitely a unfortunate circumstance where it escalated unnecessarily, and there was an unspoken, unwritten expectation that the guardian would have been involved at the outset. And again, it wasn't a legal matter. It was again more interpersonal conflict resolution matter, and it put us in a really tight spot because I couldn't point to, well, here's the university's policy or here's the institute's policy around this, and here how it's backed by either state or federal code or law or statutes. It was really kind of a values-driven process. We're going to treat this individual as an adult, as a member of our consumer advisory, as a valued member of our advisory council, and work with the individual to reach resolution. So
I actually think oh, sorry.
Go ahead, Nan. I was just going to tell you something funny. I think a lot of this is, again, very specific to the guardian at times, as I said earlier on, and so there was a parent in Western Mass many years ago who brought the suit to challenge the conditions at the Belchertown State School, but really to improve them there. And he was a guardian for a number of the class members, and a friend of ours was running a community program that was serving one of his wards, and he called her up to say that he understood that this person was having sex with his girlfriend, and he wanted her to know that he didn't have permission to have sex. So her job as a residential provider was to ensure that his ward would be celibate. And so she said, very politely back, you may think you have that authority. I don't know that any court has extended your legal authority to that point. But, if in fact you have it, you decide how you're going to make that happen. It's not going to be through me or my staff. That's not our job. And if your ward is wanting to have sex with his girlfriend, that is between the two of them. As long as they're both safe, I'm not playing a role in this. So I think that there are those limit setting things that have to happen, both in terms of being clear about, boundaries and appropriate ways of being involved. So I think that if a family member has, as the person's guardian knows that they're on this advisory council, I think personally that all bets are off in terms of, I don't think you should have to communicate in a day-to-day, minute-to-minute way about what's happening internal to that committee. Like, too bad. And I guess if they want to revoke the permission to do it, and that's within their authority, that's something you can talk to them about. But I would not kind of cede a lot of other power to them in the day-to-day operation of how you're going to be interacting with the individual. I don't think you owe it to them. I don't think they can demand that. And it's like the employer, same thing. You wouldn't have the mother of someone who's their guardian coming into the lunchroom to watch how the social interactions are going at lunch, or to tell you the best way to teach somebody how to do a particular job. I mean, they may have insights about it that you'd want to listen to at a different time, but they shouldn't be in the workplace supervising their son or daughter or ward.
That's helpful. I'm not sure if it would resolve the specific issue that we found ourselves in, but it's helpful for that kind of additional voice on that matter. I'm going to speak for others perhaps as well. Having been part of this network and this work for 15 years now, where I find that a lot of these issues come into play is the tension between kind of like the more quantitative, whether it's research or law, and the values-driven approach that advocates take to do what they think is right. And sometimes those two are create tension between the two. And I think that's what was happening here. There's a values-driven approach by the guardian that, hey, you should be doing X, whereas the details of the guardianship doesn't preclude them or us from having discussions trying to resolve these kinds of issues. Mm-hmm. So, and it can be difficult. It can be difficult at times to kind of work through this in both a productive and an amicable way.
Mm-hmm. There was something you said, Matt, that was we can just reframe. I think you said there was nothing I could point to in the law that said, oh, we have the authority to do things this way. To just make it explicit, Kathy's story illustrated this perfectly. It's totally the guardian's burden to show you what in the guardianship order gives them the authority to have whatever involvement they're imagining. And it sounds like in the scenario you're describing, like Kathy described in her scenario, there's not going to be anything in the guardianship paperwork that gives them that kind of authority for that level of involvement for the reasons that you just said. And I think it's one of the natural challenges that comes with guardianships is that there are guardians who just have a false understanding of how much authority they have. Mm-hmm. And I don't want to stereotype, but in my anecdotal experience, it tends to correlate more strongly with parent guardians because they've been in this important role in their child's life, fighting for their rights, fighting to protect them. And there are times when when a legal guardianship is established, there's maybe a misunderstanding of what that actually means. And so that blending of the legal authority they have kind of bleeding into the parental role can be complex. And that's not, I really don't mean to totally stereotype, but I think, that's just an anecdotal experience. And so I think that is where I think most likely you're going to have those kind of scenarios come up where there is that kind of misunderstanding. And I think, the way another scenario could play out is a guardian maybe thinking that they have a right to sort of burst into a workplace. It's just, in a way, what you're describing, it's it's a slightly different, but you get the analogy. So, and I think there is some, depending, this is where it's so state law dependent, but depending on the state, there might be some good legal authority making it really clear the limits of what that guardian's role is. Because I think there are enough cases, often it's about like the interpretation of what's in the law, obviously, which comes out in a case, you know, and so I think there are more, issues tend to come before a court for a decision when maybe a guardian is pushing for something they don't really have the legal right to, and then you get a court decision that says, no, this is really outside of the bounds. So that's why it's really essential, you know, when you're encountering these issues, to find someone in your state who has like a values-based, who is an expert in your state's guardianship law, who shares your values, who can give really, you know, on point legal advice about those tensions you're describing.
Yeah, that's helpful. Thanks. And I don't mean to monopolize our limited time
No,
together.
and I do want to say, it occurred to me also, like in thinking about, you know, the educational context, you know, even where, you know, you have parents who are their kids' guardians, you know, through that legal age of majority. Parents don't, all of us, you know, when our kids are back in school in real classrooms versus virtual classrooms, it's not like families can just like burst into the classroom. Parents can just burst into the classroom to tell teachers how to teach or to say how they want things to happen for their son or daughter. I mean, there are those pushy parents who try to do that, we know. But, you know, that's not what's customary and that's not what's appropriate. And so I think in the same way, you know, it's true, and, you know, you can just kind of build out from there in terms of our interactions in thinking about, you know, other kinds of opportunities for people to participate, and the way in which there are boundaries, you know, that have to be observed even by guardians.
That's helpful. And hopefully this is beneficial for everybody in the call, but just if you could just clarify, Anna and Kathy, what is the entity, in this case, the either the employer or the organization that they're volunteering for, entitled to in terms of the details of the guardianship when that relationship is established?
I don't think there's any, I don't think you are really, right? I mean, it would depend on, maybe there's something in a state law that would, you could frame that way. Kathy, does anything come to mind?
I think
really
that
voluntary.
Yeah.
Yeah.
I think that you're asking, what does the guardian have to tell you about the nature of the guardianship? Is that what you're asking, or the authorities?
Correct, yes.
I'm not sure they have to tell you anything. And that's what gets, I mean, you know, there's going to be a court order, but do you have access to that court order? Unclear. So I think you have to really, in some ways, you know, if there was some kind of legal issue, you'd obviously be able to get a copy of it in the context of, you know, if there was some kind of legal challenge to an action you had taken by a guardian, and then you were trying to understand what is the scope of their authority as it pertains to the person. I mean, I think you can ask those questions of someone. I think you can ask it of the individual who's under guardianship. I think you can ask it of the guardian, like, what is the scope of your authority here? Like, we want to make sure we're understanding it. But this is, again, one of those times where I think guardianship is one of the things that is so widely misunderstood, I think, even by guardians. And so, you know, it's like, I used to do a lot of training for families, and, you know, try to tell a mom of someone who's 19, who has been her, you know, and has a child with a disability, who's been caring for them since birth. You know, a lot of people believe that they continue to be the guardian after the adult child reaches the age of majority, because they just kind of feel like that's their job, you know, to be the mom looking out for them, and that the guardianship continues because of the child's disability. So I think there are a lot of people who believe that their family member's guardian, whether they are or they're not. Then I think there are families, once they become guardian, think it means that they decide everything about everything. And it doesn't necessarily mean that. And so one of the things we were going to just try to talk through, and Anna, you can do it, or I can just keep going, whatever you want. But there's just different kinds of guardianship, right? So there's a plenary guardianship, which is basically over everything, essentially. You know, it's not limited in any way. Those guardianships are, at least in many jurisdictions now, frowned upon, that there's the sense that the guardianship needs to be more limited or more titrated to what it is the person needs help with. So it's not just full blown, you know. So it's not just, so, and that kind of then gets into, well, does the person have, the guardian have control just over the person's finances? Is it a limited guardianship in some way? A lot of states have things called conservatorships, or it's the, like, a guardian over the estate, essentially. And that happens sometimes, as I said earlier, when there's, you know, a lot of money involved, or the person's inherited something, or there's, you know, what I was just talking to someone recently where their sibling received huge amount of money because of some a settlement around birth defects and medications that their mother had been given while they were pregnant, and so their sibling ended up dying, but while they were still alive, they had, you know, a couple $1 million that the family had in a trust for them. And so therefore, you know, the idea that their sibling could, you know, and this is somebody who is, works in the field, works for a DD council, and was telling me, you know, really, it was one of these heartbreaking things, because I wanted to believe that my brother didn't need a guardian, but he needed a guardian for that purpose. So, you know, that's a place where, yeah, maybe you need a guardianship, because at that point in his brother's life, you know, he was incapable of, you know, investing it, probably I would be too, millions of dollars, you know, and figuring out how to manage all of that, but at the same time could make a whole range of other decisions in his own life, and could speak for himself and know what he wanted and know how to express that. So, yeah, and then there's more limited guardianships of the person, you know, where it may be your inability, you know, the court will say you can't enter into contracts, but you can do other things.
Kathy, if I can just jump in, I'm wondering, in bridging Matt's question with what you're saying, it sounds like Matt might not have access to that information because he's not entitled to know what kind of guardianship it is. So would your recommendation be, from a values-based place, that you said assume the most limited amount of authority that the guardian has? Like, we just assume that they don't have any powers, and I'm going to treat them like an adult who's sitting on my advisory council, and it's going to really be the job of the guardian to prove otherwise.
I think that's I think that's a bit bolder than I would go, honestly.
Then could you expand on what, in terms of, like, from my understanding, it seems like you wouldn't have knowledge about what kind of guardianship they're under. You might not be entitled to know the specifics. So what would you recommend a you said do when, what assumptions should they or should they not make?
Well, let me just quickly add something, because I think that question is really good. What I was hearing, and tell me if this is wrong, Kathy, that even though we may not be entitled to that information, we can ask about the details of the guardianship that may pertain to this relationship, or this engagement as, say, a board member or what have you. And their willingness to provide those details is incumbent upon them. So,
yeah, I mean, I guess what I would suggest doing is this: if you know someone's under guardianship and the guardian's kind of hovering around or present or visible in the person's life in a way, you know, they're the ones. I guess I would just sort of say, you know, we want to make sure it's our expectation that, you know, your ward, son, daughter, ward, whoever, you know, that the person with a disability is going to be an advisory council member. We want to be able to treat them like every other advisory council member. We understand you're their guardian. We need to know if there's anything about the nature of your guardianship that we need to know in our, you know, in our interactions with them, or about your authorities as their guardian. in terms of what you expect from us. And then I think then you have to, and if they say, well, I want to approve each and everything that, you know, whatever it is, or I want to sit here in every meeting with them, or then you have to like really, I think then have the next conversation about, well, can you say more about the scope of the guardianship, why you would feel that would be necessary, blah, 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 you know? But so I guess, yeah, I think being in a conversation about it in a proactive way is certainly better. I mean, I wouldn't go looking for trouble if it's a guardian who's basically said, yes, it's fine for my son or daughter to participate. So on this ACL grant that we have, I got to tell you, the last thing we want to do is run around having all these separate conversations with guardians every time there's a meeting to talk about how their ward did in the meeting. It wouldn't be what I would ever want to sign up for or offer. But I do think that if, and it could be that some guardians are just so difficult that you can maybe deal with one person like that, but you could certainly not deal with a whole advisory council full of guardians like that, you know, or as a secondary member, you know, hovering in the background. So, I mean, I think the thing that's really difficult and complicated about this, and the thing that really sucks, to be quite candid, is it's always the person with the disability who gets screwed. Then ultimately, if you just get so fed up that you don't want to deal with that guardian anymore. So it's like how to keep coming back to the person and how to balance what they need and deserve with what the guardian can legitimately ask for.
And one possible solution to your situation, Matt, where without knowing all the details, maybe this wouldn't work, but I'll throw it out there. I mean, from what you've said, it's hard for, I don't know New Hampshire guardianship law. So, but from my knowledge of guardianship law, it's hard for me to imagine a scenario where there's a guardianship order that covers the kind of involvement this guardian is claiming that they have the right to have. Again, I don't know New Hampshire guardianship law, but a workaround could be that you reach out to someone, whether it's through the PNA or through the ARC. We've listed like a couple of resources in the materials that Katie will send out. Try to find an expert in New Hampshire guardianship law who can advise you. Even the most restrictive guardianship possible could never cover what this person is saying that they have the authority to do. Then you don't even need to see the guardianship paperwork. It doesn't matter, you know, and it just might bypass that particular challenge for you. It's probably something they could answer pretty quickly. You know, it would be like someone who's doing this day in, day out would be able to tell you pretty easily, you know, for your state law, what that outer limit is.
But I think if there's a plenary guardianship where it's a full-blown guardianship, guardians often think that gives them the right to decide each and everything. And unfortunately, it's probably closer to the truth than we would like it to be. So that's where it gets really, you know, you know.
Well, it is, but it's all guardian. Like, I think it just depends how you frame it, because I think there is like a, you know, one way that I sort of look at guardianship. I think guardians think they have a lot more legal authority than they actually do at times. So, yes, they have, in some sense, they have a lot of legal authority in the sense that they're able to potentially decide where someone lives, whether they have life-saving surgery or not. Obviously, those are huge things to decide about. But I think there's this bleeding out, you know, there's this sense, if I can decide those important things, I can also decide these other types of things. So I think it is more circumscribed than, the authority of a guardianship is more circumscribed than a lot of guardians start to believe. And it's you can sort of see how being in that role, it naturally would kind of, you could sort of lose perspective, you know, so.
And I think if you have like a kind of a person whose nature is to be a little meddling and a little bit of a busybody and who thinks they know best, you know, it's not surprising that they're going to insinuate themselves into some of these conversations in a way that's inappropriate. You know, I'm also mindful though, Anna, you know, like in Massachusetts right now, there's a group of professional guardians who are trying to convince the court that they should eliminate the requirement that there be hearings on whether to have do not resuscitate orders can seek decisions around DNRs on the way into a hospital admission, especially during the crisis standards. If the crisis standards of care are invoked, you all know what those are. If there's a need for rationing because of COVID-19. And so, you know, there's kind of, on one level, it's very scary. I mean, a lot of us have been working for years to limit the role of guardianship or to at least come up with alternatives to it. But it is definitely true that there is this segment of the professional guardianship world who is very much alive and active and kind of leaning in absolutely the wrong direction. I don't know how much that comes into play around employment issues, which is what we're here to talk about, but I am kind of sitting here with a sick feeling in my stomach about what else we have to deal with today, you know?
Yeah, I feel like this is such a fascinating conversation that sometimes we can get outside the box, but it's sometimes maddening, I think, when you think about some of the ways that these issues are coming up in our world right now. So I'm glad you touch on it, and this has been really helpful. I hope, Matt, for your situation, that it's helpful. I feel like I learned a lot. I hope others on the call were able to get some resources or thoughts. There's a handout that Kathy and Anna made for us, so I'm going to be disseminating that alongside a copy of the recording. And then eventually a tip sheet will be created with some more resources attached to it. It's past our time though, so I really, really just want to thank the two of you for coming and sharing your expertise, and for everyone for joining on the call. I'm going to I'm putting in the chat, though I know we're past time, a link to an evaluation survey, but I'll send it over email to all who registered.
If it would be helpful, Matt or others, to follow up on any sort of questions or specific situations you have, we'd be happy to talk with you offline.
Thanks, Kathy. I appreciate it. This has been fantastic. I do have another meeting that I need to run to.
Yes.
That's okay. I'm sure we all do.
All the best to everyone.
Take
Thanks,
care.
everybody.
Bye.
Bye now.
Thank you for your time.